I'm just going, this is from the shotgun.
Freelancer in this area, and I'm like,
We hear the shotgun.
freelancer on the area?
I don't know where it's
I guess, I don't know.
Give me a second.
It's right up there. It has a red cord on it.
I know. It's not with this. I'll get the. I'll get it. It wasn't Chris. No, he was doing this stuff.
So I did hand it.
Yeah, you're fine. You should get him known. Get him where you want to sit. I'll like take it.
All right, so this way.
You I see something now.
Yeah, I will. When I talk.
There's 2 mics. Please take your seats and buckle up.
You can keep that. I just had it.
Okay, cool. Yeah, yeah. No,
Look
that's
at
fine.
box so that she's extra copy.
Cool.
No, I'm just saying, like, maybe just or something.
Yeah, because now that I was running it
Yeah.
through in my head.
That was
Okay.
more just like, ooh.
Okay. So I'm going to give that back to you. So I don't have so many pages up here. Yeah, but that's good.
Yeah.
Then you get you right. Right. Getting there is the hardest part. I'm like, all right, now what? Right. After I told him, back out, the whole time driving.
All rise, please. The circuit court is now in session. Honorable Michael R. Olsaber, please. Thank you. You can be seated. We are on the record in file 24-21841-FC, People of State of Michigan versus Dale Warner. We are here today for a sentencing hearing, and we are proceeding today in person. First, can have counsel place their appearance on the record.
Good morning, Your Honor. Jackie Wise on behalf of the people.
Good morning, Your Honor. Mary Chartier on behalf of Dale Warner, who is standing to my left.
Sean Head, also appearing on behalf of Dale Warner.
Good morning, Your Honor. Marissa Sabinsky, also on behalf of Mr. Warner.
Good morning, Your Honor. Lizzie Saylor, paralegal for the defense.
And sir, you are Dale Warner, correct?
Yes.
Have you had an opportunity, Mr. Warner, to read and review your pre-sentence report?
Yes.
Have you had an opportunity to discuss that report with Ms. Charlier?
Yes.
Are you satisfied with your attorneys and the advice that they've given you?
Yes.
Do you wish to explain or challenge the accuracy or relevancy of any of the information that's in the pre-sentence report? And Ms. Charlier, we had a discussion
Yes.
in the jury room regarding a number of issues. If you want to address those on the record now, you can do so.
So, would you like me to address the two remaining issues? Because the other issues, I believe, have already been made and agreed to by the court and the prosecutor, correct?
Correct.
Okay.
We did agree to a number of things like name spelling,
Correct.
Those kinds of things.
Yes.
If you want to put any of that on the record, you're welcome to, but if you just want to address the issues that remain in dispute, you can do that.
I'll just address the remaining issues, Your Honor. Thank you. So on page 1 of the report under evaluation and plan, under the 4th paragraph, it indicates that per investigative report, he, meaning Mr. Warner, failed to make any effort in assisting with the search of his missing wife. My objection to that is that does not comport with the testimony that we heard specifically from Detective Singleton, who indicated that at one point Detective Singleton and his colleagues were on the Paragon North property. Mr. Warner had offered his services, including a piece of farm equipment, and he was told to leave the property. So if the court wanted to change the word any to another modifier, I think that would be more consistent with the testimony. But to say that he made no effort is inaccurate based on the testimony that we heard. Thank you.
Your Honor, I believe that the testimony presented was that Mr. Warner did not, in fact, make any efforts to search for his wife. The only thing that he indicated to Detective Singleton when Detective Singleton was at the Paragon property was offered to help dig. So if we want to change that to the only effort he made was to offer to dig the property while searching, that's the only instance I recall Mr. Warner offering.
All right, so there is in the record an instance of Mr. Warner offering assistance, and so the word any in that context would not be appropriate. I would change that word any to the word little. Amend the PSI that.
Thank you, Your Honor. And the only other general objection, and I think probably an appropriate place, would be on page 10 under the initial narrative right before the employment section, would be just a general objection that Mr. Warner maintains his innocence and disagrees with the narrative that he was controlling and that he engaged in stalking and assaultive behaviors. My understanding is that Mr. Warner will be pursuing his appellate rights, so I want to make sure that there's no issue with him waiving his assertion of his innocence by not making a general objection to the narrative in the pre-sentence report. Thank you.
All right, Ms. Willis.
Your Honor, that should be in the pre-sentence report because throughout the course of the investigation, Dale Warner, it was discovered he did display controlling, stalking, and assaultive behaviors, which was all presented at trial.
All right, my understanding, Ms. Shardy, is that you just want a statement, to include a statement that indicates that Ms. Warner disagrees with that narrative.
That Mr. Warner does. Yes, Your Honor. That's correct. Thank you.
All right, I think the inclusion of a statement, so long as it is that Mr. Warner disputes that statement and maintains his innocence, will be appropriate.
Judge, where do you want that included?
I think just at the end of that paragraph would be fine.
Okay.
points in terms of the accuracy or relevancy of the information that's in the pre-sentence report.
No, thank you, Your Honor.
Pre-sentence report does not disclose any prior convictions, so there wouldn't be any with a known constitutional defect. And the probation officer has calculated the minimum sentencing guidelines on the second-degree murder conviction to be 225 to 375 months. I am aware that there are some objections to the scoring. The calculation on tampering with evidence charge is 5 to 23 months, and there's some challenges there as well. So I guess why don't we start with the people who have some challenges in the case of defense. Or if you prefer to do go in order. Whatever way you would find.
I apologize. Did you say you wanted to start with the people on our challenges?
Yes.
Okay. Your Honor, for the guidelines on the homicide conviction, OV score is currently scored at 0 points. The people believe 50 points should be scored. 50 points should be scored when a victim was treated with sadism, torture, excessive brutality, or similarly egregious conduct designed to substantially increase the fear and anxiety a victim suffered during the offense. Sadism is conduct that subjects a victim to extreme or prolonged pain or humiliation and is inflicted to produce suffering or for the offender's gratification. The court did sit here and listen to the testimony, and we heard from Dr. Cho. Dee Warner was beaten to death, strangled, and her mouth and nose were duct taped. She was placed in a tank. Being strangled while being beaten about the head and face would substantially increase the fear and anxiety the victim suffered during the offense. Nothing about OV7 says that the victim has to actually, in fact, experience those things. The focus of OV7 is defendant's conduct and the purpose with respect to aggravated physical abuse. So not only did the defendant do those things, but once he did wrap her mouth and nose in duct tape, he placed her in the tank. It can be inferred from all of these acts, at a minimum, that they were carried out for the purpose of prolonging the fear and anxiety, the pain or humiliation that Dee suffered, and it was for his own gratification. We'd ask that the court score that at 50 points.
Your Honor, we would object to the scoring of OV7 at 50 points. There was absolutely no testimony, and there's no evidence in the record of what Ms. Warner experienced in terms of her awareness of being placed in the tank, her awareness of being duct taped, anything like that. Being assaulted, being strangled, of course, is going to be fearful to the person who's experiencing it, but it is things that are excessive that warrant the scoring of 50. Otherwise, being strangled or being assaulted would equate to the 50 points in every homicide case. So the government has not presented any evidence at trial that the things that they're mentioning here, again, in terms of being duct taped or being placed in the tank, Ms. Warner would have any awareness of. In fact, their own theory was that she had been killed in her home, and these things happened afterwards. Therefore, we would object to the scoring at 50 points for OV7. Thank you.
For OV7, 50 points are scored where a victim is treated with sadism, torture, excessive brutality, or similarly egregious conduct designed to substantially increase the fear or anxiety the victim suffered during the offense. OV7 provides 4 alternative grounds for scoring 50 points. The similarly egregious conduct clause is, under the case law, a discrete alternative to conduct that does not constitute sadism, torture, or excessive brutality. Therefore, if a victim is treated with sadism, torture, or excessive brutality, 50 points should be scored even if the defendant did not intend to substantially increase the victim's fear and anxiety. In this case, Dr. Cho testified that during the autopsy he found contusions on the right and left cheeks, the right and left eyes, the left shoulder, and contusion on the back of Ms. Warner's head. She had a contusion and abrasion on the front of her neck. Ms. Warner was also had blunt force injuries, internal bruising on the left and right sides of her head. She was surface of her skull and the undersurface of her scalp, subdural hemorrhages, and bruises about the tongue. Ultimately, the causes of death determined in this case by Dr. Cho were both strangulation and blunt force injuries to the head, either one of which he testified could have independently caused Ms. Warner's death. Essentially, she was killed in two different ways, either one of which would have been sufficient. Excessive brutality means savagery or cruelty beyond even the usual brutality of a crime. It comes from People v. Rosa, 322 Mishap 726. Ms. Warner was both severely beaten and also strangled. I think this constitutes savagery or cruelty beyond the usual brutality of the crime, even the crime of murder, as is the case here, and therefore I think the 50 points is the appropriate score.
Thank you, Your Honor. The people would also like to address OB10. That is currently scored at 5 points. The people would argue that that should be scored at 10 points for the murder conviction and 0 points for the tampering conviction. 10 points is scored when the offender exploited a victim's physical disability, mental disability, youth, or agedness, or a domestic relationship, or the offender abused his or her authority status. The gravamen of OB10 is that a vulnerable person was exploited. The court heard the testimony that Dee was extremely upset and weak that night. She had a migraine. She took medication. She went home to ask her husband for a divorce. Because of the very nature of their relationship, their marriage, the fact that they lived together, they did have that domestic relationship, and he was able to exploit her vulnerabilities to, in fact, complete the homicide. So we would ask the court to score that 10 points as opposed to 5.
Your Honor, it's my understanding that the government is agreeing that the OV10, which is scored at 5 for the tampering with evidence charge, should be 0. So we agree with that. That is one of our objections that would have been upcoming. OV10 currently is scored at 5, which would indicate that an individual exploited a victim by his or her difference in size or strength, or both, or exploited a victim who is intoxicated, under the influence of drugs, asleep, or unconscious. We did not challenge OV10 as scored at 5, but we would challenge OV10 as scored at 10, because if there was exploitation here, it would be because of size or strength. It would not be because of the factors in OV10 under the 10 scoring, which would be physical disability or mental disability, youth or agedness, none of which apply to Ms. Warner, the domestic relationship, or authority status. While, again, they were husband and wife, there was nothing about that relationship that would have been exploited at the time that Ms. Warner was killed. Thank you.
The 10-point score for OV10 requires the court to make 2 findings. First, that there is a vulnerable victim, and second, that the offender exploited the victim's physical disability, mental disability, youth or agedness, or a domestic relationship, or the offender abused his or her authority status. First, it must be readily apparent that the victim was vulnerable, meaning that the victim was susceptible to injury, physical restraint, persuasion, or temptation. Factors that evidence a victim's vulnerability include the existence of a physical disability and the existence of a domestic relationship between the offender and the victim, among other things. However, case law is clear that the mere existence of one of those factors does not automatically render a victim vulnerable. The key is that the victim was susceptible to injury, physical restraint, persuasion, or temptation. In this case, the evidence at trial was that Ms. Warner was at least partially incapacitated by a migraine headache that she was experiencing on the night the events occurred. Ms. Warner made statements to this effect. Mr. Warner made statements to that effect to investigators. There was other evidence of that from other people as well. The physical disability resulted in her being less able to defend herself or escape escape the situation and therefore more susceptible to injury or physical restraint. Therefore, I do believe that she meets the definition of a vulnerable victim. Second, the offender must have exploited the victim's physical disability, mental disability, youth, agedness, or a domestic relationship, or the offender abused his authority status. Within the meaning of OB 10, exploitation requires manipulation of the victim for selfish or unethical purposes. And that comes from People v. Ziegler, 343, Michigan 406. The definition of exploitation intrinsically establishes an element of intent. Any manipulation must have been done with the goal of accomplishing something selfish or unethical. For purposes of OB 10, exploitation part of my notes. Again, for purposes of this definition, exploitation intrinsically establishes an element of intent. Any manipulation must have been done with the goal of accomplishing something selfish or unethical. Or stated differently, for the purposes of OB 10, exploitation means the defendant intended to gain something from manipulation of the victim at some kind of cost to the victim. As an example, the Court of Appeals in People v. Yargo, 148 Michigan 139, held that a selfish or unethical purpose was established where the defendant beat her 12-year-old child to death in order to preserve her authority status in the face of a rebellious son, to vent frustration, and at his continued disobedience, or to ensure her place in heaven by chastising her son in accordance with the dictates of her religion. In this case, I think it is readily inferable from the evidence in the record that the beating and strangulation of Ms. Warner occurred to prevent her from filing for divorce and avoid having to divide a substantial marital estate with her. I do believe that qualifies as a selfish or an unethical purpose, and therefore I think the 10-point score would be appropriate for OB 10.
Your Honor, for tampering, is OB 10 scored at 0?
I believe the people agreed with that.
Okay.
Accurate, Ms. Wise.
That's correct, Your Honor.
Thank you, Your Honor.
For the tampering charge, it would be scored at 0. For the second-degree murder charge, it would be scored at 10.
Those are all the challenges from the people.
All right. Ms. Sharkey, the defense has some challenges.
Yes, Your Honor. For the second-degree murder charge, we challenge OV2 being scored at 15. This is for the lethal possession of a weapon or the lethal use of a weapon. So OV2 being scored at 15 is for when the offender possessed or used a harmful biological substance, harmful biological device, harmful chemical substance, harmful chemical device, radioactive device, or substance. the radioactive portion is not relevant here. It is not appropriate to score 15 points for this offense variable because there's no indication that a harmful substance was used in the course of the homicide. Believe this allegation is founded on the fact that Ms. Warner was put in a tank, but we have no indication at all that a harmful substance was used to commit the homicide. Moreover, from what we learned about anhydrous ammonia, that if the tank had been cut open with anhydrous ammonia in the tank, that would have been harmful significantly to the individuals around it. And so there's absolutely no indication that there was the lethal potential of a harmful biological or chemical substance used in the homicide. Therefore, OV2 should be scored at 0. Thank you.
I did discuss OV2 in my memo briefly, and I acknowledge that in this instance, Ms. Warner was dead at the time she was placed in the anhydrous ammonia tank. And if the court does not score this OV at 10 points, the people would argue for sentencing purposes to take that into consideration.
Okay, with respect to OV2, this is an offense variable that has to be scored giving consideration to the sentencing principle in pursuant to People versus McGraw. MCL 777.32 does not specifically authorize the court to consider anything outside of the sentencing offense. There was not evidence in this case that during the commission of the murder that any biological, chemical, or radioactive substance or device was used or possessed. I understand that there was a lot of chemicals around the farm and that it may have later played a role in the tampering portion of the case, but there wasn't evidence in this case that it played a part in the commission of the murder, and so I don't think any score for OV2 would be appropriate. I would set that at 0.
Thank you, Your Honor. We are also challenging OV14, which was scored at 10, and that 10 points is scored, indicating that Mr. Warner was a leader in a multiple offender situation. There's literally no evidence on the record that there was another person in the house other than Mr. and Ms. Warner based on the government's own theory of when she was killed. So that should be scored at 0. Thank you.
Your Honor, when scoring OV14, the entire criminal transaction should be considered. In this case, there was evidence presented that on April 27th, 2021, Dale Warner, in fact, enlisted his son to come and pick him up to help him move that tank. At the time that his son received that phone call, the police were there and explained their intent to search the property. And his son indicated at that time, confirmed that the dogs were on their way, said his dad was still out planting, and in fact did go pick up his dad, brought his dad back to the property so that he could, in fact, move that tank. So OV14 is correctly scored at 10 points.
Your Honor, there is literally no evidence that Jaron Warner knew that his father was going to be moving a tank. So if we look at the entirety of what the government presented, Mr. Warner spoke to his son on the telephone. His son went and picked him up from another property, brought him back to the Munger property. What Mr. Warner did after that was Mr. Warner's choice. There is not one shred of evidence that his son knew anything about a homicide or moving a tank or that Ms. Warner was in a tank. So to say that he enlisted his son to move the tank is belied by the fact that there is literally no evidence that Mr. Warner asked his son to pick him up so that he could move a tank. That should be scored at 0. Thank you.
For purposes of OV14, a leader is defined in relevant part as a person or thing that leads, a guiding or directing head as in an army or political group. And to lead is defined in relevant part as, in general, guiding, preceding, showing the way, directing, or conducting. That comes from People versus Rose 305, Michelle 85. In this case, there is some evidence that Mr. Warner and his son were acting in concert in moving Ms. Warner's body after it had been placed in the tank. However, I don't think there's sufficient evidence to establish that Mr. Warner was the leader in that endeavor as it's defined under the law. There simply hasn't been sufficient evidence regarding whether one encouraged or directed the other, and therefore I don't think it's appropriate to score points for OV 14.
Thank you, Your Honor. And finally, for the second-degree murder, and then I'll move on to the tampering charge, OV-19 was scored at 15 points. 15 points is scored if the offender used force or the threat of force against another person or the property of another person to interfere with, attempt to interfere with, or that resulted in the interference with the administration of justice or the rendering of emergency services. As we look only at the sentencing offense, according to People v. McGraw, there's no indication that Mr. Warner interfered or attempted to interfere with justice as it relates to the homicide. It's a different analysis for the tampering charge, which I absolutely admit and which I'll discuss when we get to that offense. But as we look at the murder charge, there is absolutely no evidence of a threat that would warrant the scoring of 15 points. Thank you.
Your Honor, McGraw does not apply to OV-19. OV-19 may be scored for defendant's conduct after the completion of the sentencing offense. People v. Smith, 488, Mich. 193. In this case, the force that was scored was against the property of another. And if you look at this case, the defendant used force when he opened the anhydrous tank. When he disposed of Dee Warner's property, he had to use force to pick those items up and remove them. The people would argue that 10 points should be scored here. We agree that the 15 points should be scored. However, at least 10 points should be scored here because, again, the court can take into consideration the conduct after the completion of the sentencing offense. So, again, we would ask for the score of 15 based on the law provided in the memo, but at a minimum 10.
And I'd like to just point out People v. McDonald, 293, Mishat, 292. Where OV-19 was properly scored at 15 points, where the defendant told the victim that he knew who she was and that his boys had been watching her and required her to promise not to contact the police as a precondition to letting her go. That's what rises to the level of 15 points of scoring for OV-19, not conduct that is inherent in the offense and, again, that does not show any force or threat of force. Thank you.
All right. OV-19 can be scored in consideration of conduct that occurred after the sentencing offense was committed. People, I think, appropriately cited People v. Smith for that proposition. Because the circumstances described in OV-19 expressly include events occurring after a felony has been completed, the offense variable provides for the consideration of conduct after the completion of the sentencing offense. Force, as defined in People v. Smith, is strength or energy exerted or brought to bear to cause the cause of motion or change. In the Smith case, the court used the example of throwing a cell phone into a lake to prevent a victim from calling the police, and found that was a sufficient use of force for scoring OV-19 at 15 points. Applying that logic here, Mr. Warner used force against Ms. Warner's body when he moved it from the house where the crime occurred into the tank and then ultimately ending up on the Paragon Road property. Obviously, that hampered, hindered, or obstructed the administration of justice, and so 15 points is the appropriate score for OV-19.
Your Honor, I think for the second-degree murder charge, then that leaves us at PRV score of 10, level C, OV score of 140, level 3, which is the same guideline range, 225 to 375, with an upper limit of life. I just want to make sure my scoring is correct before we move on to the tampering, if that's okay.
That is consistent with the map that I have.
Okay.
Yes, Your Honor. Sorry, it took me a minute.
I was trying to go as we were going along. Thank you, Your Honor. For the tampering with evidence charge, we only have 2 issues. One, again, is OV-14 being scored at 10 for tampering with evidence as being the leader in a multiple offender situation. Same arguments that I made for the homicide are applicable here. A phone call, picking someone up and bringing them back to the property with absolutely no evidence of what that conversation entailed does not warrant a scoring of OV-10. There is literally no evidence that Mr. Warner's son knew that Ms. Warner was in a tank, that she had been killed, that a tank was going to be moved. Absolutely none. It is really speculative to try to equate a phone call and then Mr. Warner's actions afterwards with the fact that his son supposedly knew what he was going to engage in. So I would ask for that variable to be scored at 0. Thank you.
Your Honor, I would make the same argument, and I understand the court's ruling as to OVs 14 and 19 on the tampering with evidence.
All right, I would adopt the prior ruling here. Again, I don't think there's a preponderance of evidence to establish that Mr. Warner was directing or leading as opposed to some assistance being offered. And so I don't think that score is appropriate to use that or set that at 0.
Thank you, Your Honor. And then similar arguments for OV-19. We believe that OV-19 should be scored at 10 for the same arguments that I made on the homicide charge. Thank you.
Again, Your Honor, same arguments, and it should be scored at 15.
All right, there are no analytical differences for purposes of this OV between the second-degree murder charge and the tampering charge, and so the court would score that the same way at 15 for the same reasons. I believe that leaves us with a total offense variable on the tampering charge of 30, which would not change the calculation.
So I think it's 15.
I believe it would change it to 15 as well,
Right.
Your Honor.
So I believe it's the PRVs are scored at 10 points level C, and the OV is 15, and I'm pulling up the grid right now.
Then it would be 0 to 17. OV level B, or PRV level B, and OVs 2, C2.
0 to 17, correct.
All right, before the court passes sentence, then Ms. Shardy, is there anything you'd like to say on behalf of Mr. Warner?
Yes, Your Honor, thank you. The court heard the testimony, and a significant part of that testimony was about Ms. Warner and who she was as a person and how much she was loved by her family, her friends, and the community in general. So there is no doubt that this case is a tragedy because Ms. Warner's life was cut short. She is mourned by so many people who loved and cared for her, and they always will. Her death has devastated the lives of so many, none more than her children. She had 5 children, and while other family members and friends and community members mourn her passing, her children are the ones who are going to feel this loss the most. This court is well aware of the factors used to determine sentencing, so I won't go through all of those, but I would just like to point out Mr. Warner has no prior convictions whatsoever. Those who knew him and know him best describe him as being a kind and even-tempered man who gave a lot to the community and tried to help out others when he could. Even when he was in jail, he showed compassion to other individuals, men who were being released who needed, for instance, clothing, and he asked his family to donate some of his clothing to them. He also used his time in jail to further his faith, which has helped him get through this ordeal. And while the case is undoubtedly tragic and extremely serious, this court knows that we are all more than the worst things that we have ever done in our life. I would ask this court to consider all aspects of Mr. Warner in imposing concurrent sentences. My understanding is that Mr. Warner is choosing not to make a statement today, but he would like me to say that he loved his wife, he maintains his innocence, and he did not kill his wife. Thank you.
All right, Mr. Warner, I understand your attorney just said you did not want to make a statement, but I believe I'm required to address you directly on the record. So if there's anything you would like to say before the court passes sentence, you have that opportunity. Ms. Wise.
Yes, Your Honor. There are a number of people who would like to address the court, and we kind of briefly discussed it in chambers. I don't know if you want to go through those individually, if you've made a ruling, or how you would like the people to proceed.
First, I think I'd like to give both sides an opportunity to state their positions for the record, and then I can make my decision.
Okay. Your Honor, I believe as far as T.J. Bach and Raquel Bach are concerned, there's no objection to those speaking at sentencing. We have Greg Hardy, no objection. Shelley Hardy and Parker Hardy, I believe there's an objection to those two speaking, as well as Catherine Adams. The sentencing court is afforded broad discretion in the sources and types of information to be considered when imposing a sentence, including relevant information regarding the defendant's life and characteristics. Shelley Hardy has been married to Greg Hardy and has known Dee almost her entire life, at least as long as she's been married to the defendant, and has been around the defendant for the entirety of that marriage. Catherine Adams was a family friend who has been around for a little while. So I would ask the court to allow those people to address the court.
Thank you, Your Honor. We understand that the Court of Appeals has indicated that the sentencing court has broad discretion in terms of who to hear from. But the statute is clear on who is allowed to submit an impact statement or who is to make an impact statement. Ms. Warner's children absolutely are covered by the statute, as is her brother. He is a sibling. But Ms. Hardy, Parker Hardy, and Catherine Adams are not covered by the statute. So while the Court of Appeals gives the court discretion, it is counter to the specific language of the statute and runs afoul of statutory interpretation. Ms. Adams is not related to Ms. Warner at all. She's a family friend. Parker Hardy is a nephew. Shelley Hardy was a sister-in-law. So we would object to those letters or individuals speaking at sentencing. Thank you. Oh, and I'm sorry to be clear, I think there was another letter from Ms. Warner's lash professional that we would ask the court not to consider as well because she's not part of the statutory framework. Thank you.
People v. Albert 207, Mich. App 73 specifically addressed the Crime Victims' Rights Act in making their decision, stating that the judge, in fact, does have discretion despite the fact that they're not victims under the Crime Victims' Rights Act, Your Honor.
All right, people are correct that the court has, according to the Court of Appeals, broad discretion in the sources and types of information that can be considered when imposing a sentence, including relevant information about the defendant's life and characteristics. I think in this case that Ms. Hardy and Parker Hardy have relevant information to Mr. Warner's life and characteristics, in addition to being in-laws of Mr. Warner. These people all live very close together, adjacent together. They spent a lot of time together. They did business together. And so certainly Mrs. Hardy and Parker Hardy would have relevant information. And so I would allow them to give a statement, but I think that is where I would draw the line.
Thank you, Your Honor. I'd ask Shelley Hardy if she can come up at this time.
All right, so before we begin the victim impact statements, I'll just make a few general comments about how they need to proceed. First is as each person comes to the witness stand, I'll ask you to state your full name and spell your full name so that we have it correctly in our record. I'm also going to ask that every person getting a victim impact statement address the court and tell the court what the impact of the crime has been on you. This isn't an opportunity to name call or anything like that toward the defense attorneys, or anything like that. There's a level of decorum that I will require people to abide by. I understand it's a very emotional situation, but again, there's a level of decorum that we all need to abide by in this process. So Ms. Hardy, you can proceed.
I'm Shelley Hardy, SHELLEYHARDY. Can I start? Here we are finally, the day of judgment for Dale Warner. Some things in life, no matter how young or old, we can't understand why. Life and death, two most important things that happen to every single one of us. We never know when we are chosen to leave this earth, but I have learned that the horrific word murder is not one we can ever imagine would happen in a lifetime. Our minds have been chosen to go somewhere that is not normal or comfortable to be included in that club. Dale, you have taken Dee from us when I so wished you would have turned and walked away. You not only destroyed all of our lives, but also the lives of your children and families, and You not only destroyed all of our lives, but also the lives of your children and families, and especially Angelina's. You took her mother from her. I only hope that every night when you close your eyes, you see the beautiful face and smile of Dee, and that her image then turns to her lifeless body, nose and mouth, duct tape. Remember that last image. We will keep her alive in our hearts, her laughter and love of life, that you will never be able to have control of her again, and knowing that you will never be free again to walk on our land or your land again, but hopefully will be your judgment for your life in prison. Dee knew we would fight to the end, and we won. And now I'm going to remove my bracelet that I've worn since Dee was missing, because we got justice. Thank you.
I'm Raquel Bach, RIKKELLBOCK. Okay. Good morning, Your Honor. My name is Raquel, and I am Dee's youngest adult daughter. I am also the mother of 3 of Dee's beautiful grandchildren. My mom was blessed to meet 2 of them, but my youngest will only know her through the stories we share. She was my first child care provider for my older 2 children, and caring for her grandchildren brought her so much joy. After her tragic death, I was left without child care for my 6-month-old baby, and my siblings had to help me pick up the pieces. That is just one of many ways her loss continues to affect our family every single day. I have thought long and hard about what to say after all these years of living through this living nightmare. The question that always has stayed with me is why. Unfortunately, I now believe the answer is selfishness and greed. The only thing Dale cared about more than himself was money, and that is why we are here today. Dale was nothing without my mom. She was the force behind everything he now wants to claim as his own. She was a force that he could no longer control, and because of that, he took her life. He stalked, manipulated, and preyed on the very person he was supposed to love and protect, his own wife. He brutally beat her, strangled her, and then, as if that was not enough, he duct taped her hands and mouth. He wrapped her in tarp and hid her in a tank and tried to conceal the truth of who he really was. The cruelty did not end there. He cut off all communication between my little sister and the rest of our family. He made her believe that her own mom had simply walked out of her life to start a new one in another country. The trauma he has caused that child is something she may never fully recover from. He took away a beautiful soul, a mother, a grandmother, a sister, an aunt, and a friend. He left his own young daughter without both a mother and a father. He left 4 adult children without her mother and 7 young grandchildren without their grandmother. Our mother was the foundation of our family and a source of strength for so many others. She was our protector, our supporter, and our motivator, and our best friend. Her death created a pain and burden that none of us will ever fully recover from. We're all still trying to learn to live without her. My mom's name, Dee Hardy, will live in our hearts and our community for an eternity, but Dale Warner's name will be gone forever. The emotional and mental damage Dale has caused, especially to our youngest sister, is something that can never be repaired. Throughout this entire investigation and trial, he has shown no remorse and taken no accountability for his actions. He deserves no mercy now. My mom does not get a second chance at life, and neither should Dale. Your Honor, we ask that you use your best judgment in sentencing Dale and impose the maximum sentence allowed for the crimes he has been convicted of. He did not just take the life of his wife, he took the mother of 5, a grandmother, and the heart of our family. Thank you.
Hi, my name is TJ Bach, TJ B-O-C-K. It's almost over now. Dale Warner will no longer have control or influence over anything that matters. The damage he has caused will take years to repair. Some will recover slowly, others never will. There are people whose lives were altered, whose futures diminished because of his selfish and deliberate actions. And then there's our mother, Dee. He took her life. He tried to erase her, but he failed. She was more than just a person. She was the force behind everything he became. He cannot destroy what she created, the lives she shaped, the relationships she built, and the passion she poured into everything. In killing her, he did not just destroy our family, he exposed himself. Before Mom, Dale struggled. He lived in a camper and barely could turn a profit on the bit of land that he worked. When she came into his life, she built something with him. She handled the details he ignored. She created stability. She gave him the opportunity to succeed. Everything he became was because of her. And when he killed her, he proved he could never replicate what she was. Instead, he dismantled what she built. He sold off her assets. He took out loans in her name, even months after her death. His actions were not just violent, but calculating and self-serving. Dale doesn't take responsibility. He manipulates, he distorts reality, and he shifts the blame. He involved his own children and family in this deception, pulling them into his lies, using them to cover the truth, and turning them against the people who refuse to believe him. And while I'm angry, I also recognize this. They are victims too. They were manipulated, used, and in some cases implicated in the crimes. The truth they now face is dramatic and lasting. Some still cannot accept it. The denial will cost them relationships, opportunities, and maybe their place in the broader community. Dale Warner was not always just the defendant to me. He was my stepfather. I did not come to this truth easily. I searched for answers. I resisted. I did not want to believe he was capable of this, just as I did not want to believe my mother would ever leave without saying a word to us. But only one of these things was true. And I know my mother's love. Dale does not hurt people out of anger. He hurts them for control. People only have value to him as long as they serve his goals. When my mother no longer did, when she wanted independence, he made a choice. He chose to kill her. He chose to destroy our family. And he chose to lie about it. He prolonged our pain as long as he could. Now the truth is known, his influence is gone, and thankfully his freedom is now gone too. If he is ever considered for parole, I will be there, I will speak, I will write, I will do everything in my power to make sure he's not released. There's no place in society for someone who can take the mother of her young child and leave her to question whether that love was ever real. He shows no remorse for the harm he causes, only for the consequences he faces. This is not something that time will fix. This is not something that a person will ever age out of. That is why I'm asking for the maximum possible sentence. For my mother, for the victims, and for future victims. Thank you.
Your Honor, in the interest of the court, I would like to briefly state the effects of the criminal actions of Dale.
Sorry, I'm not sure. I just needed to state your full name.
I'm sorry. Parker Hardy, Parkerhardy. Criminal actions that Dale John Warner had on myself and on my family, more importantly. Since the day he murdered my beautiful aunt, I felt an unease of staying at my home that I have lived in for over 10 years, and the farm that I have been at almost every day of my 31 short years. Living only 1 mile away from my aunt's property and being the only son of the man who pushed tirelessly for justice, I felt as though myself and my farm were on the front lines of a long, drawn-out battle. Every night for over 3 years, until he was finally arrested, I restlessly tried to sleep, with one eye open because of the fear of what Dale Warner would do next. Unfortunately, over those next 3 years, while it will never be proven, unfortunately, I know for the fact that Dale Warner proceeded to attempt to torture myself and my family by violently vandalizing the very farm that was bringing justice to his wife and proving him guilty. Dale, I know every act of vandalism you did to try to cause harm and pain to my family. Killing my aunt apparently wasn't enough in your mind. You needed to dig deeper, didn't you? Slashing bales, cutting fence wire so cattle would get out on the roads and be harmed, unchaining gates, throwing rocks and fence wire into our hay fields, and finally your ultimate senseless act of burning my barn and office to the ground, while I was right across the street from it. Thank God my senses were on point that night, because I knew you were after me when I ran out of that house to save my cattle as they burned alive, trapped in the very barn that you set ablaze. Unfortunately for you, Dale, you didn't win. As a matter of fact, I should thank you for giving me the opportunity to make Dee's home farm more beautiful than it's ever been before. Since your vicious acts of arson, I have not only completely remodeled the farm, but I've installed the most state-of-the-art security system money can buy. I can see every inch of that farm, including the very path you used to walk from Dee's house to the dairy you set ablaze. Your Honor, this man has drove me almost to the point of seeking medical attention. Unknown to anyone, I even made the appointment, but canceled it the day before, because my beautiful aunt came to me in spirit and told me to never let that psychopath win. And I didn't. Your Honor, I ask that you use every ounce of power you have and sentence this man with the strongest sentence to prison possible. If he were to get out alive, I can promise you the first place he will head is for revenge on the very farm he burnt down before. I ask that you see that he is taken far, far away from this hometown so that the family isn't able to visit him. After all, it's only fair, isn't it? There is no visitation for us in heaven until the good Lord calls us there. Thankfully, he won't be calling you there, Dale. Thank you, Your Honor.
Your Honor, I'm Greg Hardy, Greggorry, Ray, R-A-Y, H-A-R-D-Y. Ms. Chartier, your legal comments have helped me to state that Dale John Warner, you're a narcissistic, psychopathic liar and murderer. Your lack of any remorse for brutally killing my sister is unforgivable and deserves to be punished by the fullest extent of the law, and you certainly deserve more. The barbaric act of covering up your crime by welding my sister in a cold steel tomb is beyond human. You maliciously went to all ends to lie, deceive everyone about the murder you committed. These deceptive acts fully express that you preemptively planned this vicious act well before you committed the heinous crime. And even though the jury was not given enough information and evidence to officially convict you, it certainly was premeditated. Your sneaky retribution you imposed on me and my family simply because I refused to buy your disgusting story about my beautiful sister just left you, that's criminal in itself. The vengeance acts of vandalism that you committed against me and my family that have gone unadjudicated are blatant and criminal. The economic damage you imposed on me, not to mention the emotional fear you attempted to impose on me and my family in your quest to get me to stop seeking justice for Dee, is outrageous. You are a spineless piece of human debris.
Okay, Mr. Hardy, I'm going to ask you to confine your comments to addressing the court and,
I'm sorry.
as I said, not engage in that kind of behavior.
I'm sorry. To the court, I only hope that the only way Dale Warner is able to leave prison is in a small dark box. May God absolutely have no mercy on him whatsoever. Thank you.
Your Honor, we have two people who came together and got married. Each of those people, the defendant and Dee, had their own 4 children, and they made a child together. They essentially created an empire. Once Dee decided she wanted to get divorced and be done, she wanted to be done. She wanted to sell up everything. In this case, the defendant told her that was not up to her and that was not going to happen. He manipulated the family, law enforcement, friends, into believing that she had walked away voluntarily, that she had a drug problem, that she was suicidal, that she was living in Jamaica with the cartel. It was a number of stories, and the time frame of when she would return home always changed. 3.5 years this went on, for 3.5 years. When she was finally found, Your Honor, I know the court couldn't score OV2, but she was found inside an anhydrous ammonia tank. The court heard the testimony about the dangers of anhydrous ammonia and the people that had to cut open the tank, the law enforcement officers that were exposed to that, the medical examiners that were exposed to that, and 3.5 years to bring her home. And the youngest daughter of both Dee and Dale, the entire time being told that her mother's left her, her mother's abandoned her. The number of phone calls where that little girl was begging her mother to come home, not understanding why she left in the first place. The OVs in this case are over 100, at least 40 points. They are 40 points over 100. For all those reasons, Your Honor, we would ask the court to follow the recommendation and sentence the defendant at the top end of the guidelines and sentence him to a term of 31.25 to 60 years. Thank you.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, her history, the principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what's been said on the record here today. In addition to that, I have reviewed the pre-sentence investigation report. Obviously, I have reviewed I believe I'm up to 10 letters now submitted with the pre-sentence investigation report. I received 7. I received, I think, an additional 3 this morning. I've also reviewed the people's sentencing memorandum, the defense sentencing memorandum, and 15 letters that were attached to that memorandum. It goes without saying that the tragedy of these events is immeasurable. Mr. and Mrs. Warner had a large family. They built up a large business in this community. And I'm sure that there were many happy times along the way. The letter submitted on behalf of Mr. Warner described him as hardworking, conscientious, and generous. The victim impact statements that I've heard today and that were attached to pre-sentence investigation report tell a different story. The job of the court is to attempt to balance those versions of Mr. Warner and craft a sentence that is proportionate to him and to the crime that he has committed. Obviously, murder is among the most serious offenses that we deal with, and most would say it's the most serious offense. And for good reason, because of the scope of the loss, which in this case is immense. Assuming that Ms. Warner had an average life expectancy, she had about 29 years of life stolen from her. But it's not just the 29 years that were stolen from her by this act that the court considers in crafting a sentence. It's the impact of the 29 years that were taken from sons and daughters who no longer have a mother. 29 years that were taken from grandchildren who no longer have a grandmother. In some cases, will never get to know their grandmother. 29 years of a sibling that doesn't have a sister. 29 years taken from aunts, uncles, cousins, nieces, nephews, and 29 years taken from friends, of which there appear to be many. Of particular impact are the 29 years taken from the daughter that you and Ms. Warner shared together at such a tender and impressionable age. For the sake of her privacy, I will not detail the impacts that this tragedy has imposed on her that I am aware of. Suffice it to say that I have read the letter from Dr. Henry, and it weighs heavily on my mind in determining a sentence that suits the offense and the offender. A sentence that is proportionate. The manipulation of that relationship, that she was made to doubt her mother's love for her, is an unconscionable harm that no number on an offense variable score sheet could ever adequately represent. There were a number of statements in the letters I received about closing a chapter, beginning healing, and moving on from this tragedy. Unfortunately, this is one of those types of tragedies where the chapter doesn't always end. As Mr. Bach said here earlier this morning, some will never recover from the injuries, psychological harm that they experience as a result of these crimes. The court is required to impose concurrent sentences, meaning the time runs together, unless there's statutory authority for imposing a consecutive sentence. The tampering statute, in this case, MCL 750.483A, provides that the court may, or has discretion, to order a consecutive sentence, in this case, for that charge. And when I consider whether it's appropriate for the court to exercise its discretion in ordering a concurrent or consecutive sentence, first I think about what constitutes tampering with evidence, or what can constitute tampering with evidence. And that is a wide range of actions. Tampering with evidence in some cases could mean shredding a document or flushing some drugs down the toilet, anything done, no matter how small, to conceal the evidence of a crime. In this case, Mr. Warner welded his wife's deceased body into a fertilizer tank where it remained for more than 3 years. So in looking at that spectrum, we are at the most heinous end of what actions might constitute tampering with evidence. I also look at the severe emotional distress that was caused by that tampering with evidence. Although OB4 is scored for this offense, it doesn't take sufficiently into account the scope or intensity of the psychological impacts of the offense. In this case, Ms. Warner's loved ones and friends were deprived for more than 3 years of their opportunity to properly grieve and mourn their loss. Instead, they were doing everything possible to search for her, holding on to some slim hope that she may still be alive. All the while, she was sealed into that tomb and left in a barn. Fact of which Mr. Warner was aware and had the ability to end that suffering at any time, and chose not to. Although certainly not as significant as that, I also look at the public and private resources that were required to uncover the crime as a result of the tampering that occurred. Again, the body was concealed for more than 3 years. During that time, a tremendous amount of public and private resources were deployed in an effort to find her. Seemingly an endless amount of searching on various properties in different locations, all of which didn't need to happen but for tampering charge. And so in considering those factors, I think it's very appropriate that a consecutive sentence be imposed rather than a concurrent sentence. If there weren't a consecutive sentence imposed under these circumstances, I don't know when it would ever be appropriate. And so for those reasons, I do believe that the sentence at the top of the guidelines is appropriate, and that the tampering charge be served consecutively to the murder charge. Therefore, it will be the sentence of the court that, Mr. Warner, you serve 375 months, 31.25 years to 60 years with the Department of Corrections. You have credit for 898 days served. With respect to the murder charge, you must pay a $130 crime victims assessment, a $60 DNA fee, and a $136 state cost. With respect to the tampering charge, it is the sentence of the court that you serve a period of 17 months to 10 years with the Michigan Department of Corrections. There is no credit for time served on that, and that shall be served consecutive to the sentence for the murder charge. You have the right, Mr. Warner, to request an appeal of your conviction and your sentence, and to request the appointment of an attorney to assist you with that. The bailiff is going to hand to you 3 copies of a notice of right to appellate review and request for appointment of attorney form. I'm going to ask you to sign the top copy of that form and return it to the bailiff. That simply indicates that you received 4 copies of those forms. The record should reflect that I do have a signed copy of the notice of appellate rights form for Mr. Warner, and I'm placing that in the file. Mr. Warner, if you want to request an appeal and request an appointment of attorney to assist you with that. Again, you need to fill out the remaining portion of that form and mail it to the address listed in the form within 42 days. Or if you know that you want to fill that out now, we will give you an opportunity to fill that out now and return it to the court before you leave the courthouse this morning. Is there anything else we need to address on the record this morning? Otherwise, I'll make sure you.
No, thank you, Your Honor.
No, thank you, Your Honor.
Thank you. The court will be in recess. All rise.
adjacent to the Hardys since the 1800s. I'm one of the people that have helped lead the Justice for Dee movement, a group that grew to more than 25,000 people who refused to let Dee be forgotten. For 4 long years, we searched for her. We searched fields, barns, woods, and back roads. We organized rallies and protests. We held candlelight vigils. We handed out bracelets with her name, printed flyers with her photo, hung signs in yards, and paid for billboards. We begged the media for help. We spent our days off putting up posters instead of spending time with our families. We invested countless hours, enormous amounts of energy, and our own money to try to find Dee. All the while, Dale Warner knew exactly where she was. While we were running ourselves ragged, desperate for answers, he sat silently knowing the truth. He watched as an entire community grieved, worried, searched, and hoped. We watched Dee's family suffer through years of unbearable uncertainty. That kind of cruelty is something most of us in this courtroom could never imagine. Dale did not just take the life of his wife, and I would like to be very clear about something. Dee was never his property. He took a mother, a sister, a friend, and a pillar of this community. To so many of us, Dee was our biggest cheerleader. She was the person who encouraged you when you doubted yourself. She was the voice of reason when life felt overwhelming. She stood by me during one of the biggest moments of my life, adopting my daughter. Dee was murdered just 1 week before the adoption was finalized, and we never got a chance to celebrate together. Instead, my daughter and I now carry matching tattoos of Dee's handwriting taken from the adoption records. Even yesterday, I caught myself reaching for my phone to text Dee and tell her that my son was named Student of the Month, before remembering she wouldn't be able to answer. That is what was taken from us. She was a light in people's lives. But I would like the court to know something else. After Dee disappeared, the other Justice for Dee admins and I made a promise. We promised that if someone tried to silence her, we would make her voice become louder than ever. Through the Justice for Dee movement and the thousands of people who stood by us, Dee's story reached far beyond Lenawee County. It reached across the country and around the world. Dee once dreamed of being in People magazine. While none of us would have ever chosen the reason that it happened, her story made it there because Dee mattered. She mattered to her family. She mattered to this community. She mattered to the tens of thousands of people who refused to stop searching for her. And there is another layer of pain that for many of us that are sitting here today. I have also known Dale Warner for most of my life, not as closely as Dee, but long enough to believe he was someone that we understood. He showed cows at the fair with my dad, he graduated high school with my uncle, and his children grew up alongside my younger cousins that I babysat. Learning that he was capable of this has been earth-shattering to this entire community, and the betrayal runs deep. Even in the face of that betrayal, Dee's voice was never truly taken. Today, it lives in the lives of the people that loved her, in the community that fought for her, and in the truth that was finally brought to light in this courtroom. For 4 years, we searched for Dee while the man responsible watched us all suffer in silence. For 5 years, we waited for justice. Today, we ask the court to sentence Dale Warner to the maximum sentence allowed by law for the devastation he caused not only to Dee, but to this entire community. He devastated her family, he took a mother from her children, he shattered friendships and trust. He created a division in this community within friendships and within families, including my own. The ripple effects of his actions will last for generations. Dee Hardy was not invisible, she was not disposable, and she was not his to take. She still matters, and she always will. There it is.
So the judge ruled both the maximum sentences and consecutive sentences, what was your thought right then when that happened?
Obviously, that's a lifetime for him, but in my opinion, it'll never be enough. I think it works out to 32.6 years. Obviously, that's life for him.
That would be the minimum.
The minimum, yeah. We're not going to get her back, so I don't know that justice is exactly what we thought it would be, but we're closer to it. We're closer to it. Thank you. What's that? Greg? Yes, Greg and Parker are right there. Greg and Parker! Oh.
What's everybody doing here? Well, what a lot of company.
All right, so just to start, so everyone has it again, can you just say and spell first and last?
I'm Greg Hardy, Gregghardy, and I'm Dee's brother. And it's a happier day today, right?
How are you feeling after hearing the sentence?
Relieved. It is something we've been working for 5 years. I thought the judge did a tremendous job of analyzing the information and professionally delivering it on the record. A great job by the judge.
How did it feel saying your piece to jail?
Well, there's plenty more I'd like to say. Tried to condense it down to the important things, at least for me. It was awfully difficult for all these years to listen to this continued lie, and his personality reflects and his actions reflect the fact that he's exactly what I called him, a narcissistic psychopath. And even apparently his attorneys followed that same process. You can talk about legal defense if you'd like, but somewhere there should be some ethics. And we seem not to be able to do that anymore. So if you want to sell your soul, I guess you could be a defense attorney.
What do you say to Dale right now who's watching the jail cell?
You deserve more. The idea of absolutely no remorse, no emotion of remorse, no indication whatsoever of sorrow by either he or his family is absolutely criminal in itself. That's unacceptable for a human being. And so, as I mentioned, his act of entombing her was a non-human act. It truly was. And it appears we don't seem to want to put I think the judge put all the emphasis he could, but as a society, we should not accept that. It's just not enough.
And the judge had stopped you in there a little bit, saying some stuff you can't say. Is there anything you can tell us that you couldn't say in the courtroom?
Well, I got it out. I mean, you can't take a word back, right? I think the part he stopped me about was I called Dale a piece of human debris, which I've done before publicly, and that's because it fits perfectly. Okay, I mean, that's just what fits. So, but the judge did take a technical issue to that I was addressing Dale instead of the court, and that's fine.
What was it like to watch him while the sentencing was being said, while the victim impact statements were being said? Did you notice any emotion on his face at all?
Watching him is like watching a still shot. It never changes. He has no emotion. There's nothing that impacts this guy except himself. And that tells the story. I mean, it's kind of interesting. You don't have to have anybody else bring the evidence forward. He tells the story himself. And And that's been his MO from the first day after she went missing. Sorry.
As like any reaction to the judge assigning consecutive sentences instead of concurrent, so he's got to do one then the other instead of.
My reaction, you mean? Good job, Judge. That's my reaction, and it should be that way. There's nothing about her death that should be reoccurring that way. I mean, that's crazy. So I thought the judge analyzed that, reviewed the facts of law, and did a great job of communicating that on the record and to the public.
This is the first I'm hearing of this, but the vandalism you're accusing Dale of to your family's property. Can you elaborate on that?
Yeah, Dale's a vindictive person. It's pretty obvious. That's one of the traits of a narcissistic psychopath. And so what he tried to do to start with, and I don't want to make this too long for you, but it's important to understand where we got to from there. When we started, he was trying to convince everybody that she was the bad person, she left him, and it was poor Dale. Okay? In fact, his first statement to me on Monday morning after she was found missing on Sunday, when he came voluntarily to my office to speak to me, was, quote, "She left me in a hell of a mess." That's a guy who killed his wife hours before and had that kind of a statement to make. So what he did, he tried to play me. He tried to get me to be on his side. He tried to get me, he really thought he could get me to be against my sister because my sister and I would spar. And he thought he would play on that. And so eventually he figured out that wasn't working. So then he goes to the next step for a guy of his mentality. That's intimidation. So he starts out doing what, by the way, this isn't the first time he's done that thing to other people. He's done that to other neighbors. When he was in a dispute with them and couldn't impact them, he would go behind their back and do those kinds of vengeance things. So he started with us, doing things that he could get away with. He knew they were damaging. He was a farmer, right? So he'd do these little things like cutting round bales. Did that twice. Drove a long stake out in one of our fields that we were mowing, so the equipment, when it hit it, would destroy it. He knew how to do these kinds of things, which were all vengeance activities. And then, of course, the largest one is and let's be perfectly clear. I've never proven this, but it's my opinion. The arson that took place at our dairy, the circumstances around it, which are in detail, and I won't share all with you now, but it was very specific that this was arson. And there's no one else who had any kind of a motive whatsoever to do that. And he knew exactly how to do it, where to do it, and what damage it would cause. So those are the things, and they were done all out of intimidation. He wanted to stop me from hunting him down.
When did that fire happen?
That was in July of 24.
So right about the time the body was found.
No, before the body was found.
Right,
Before he was actually arrested the first time. So I got to check my dates.
That would be 23 then.
Yes, that would be right. Yes, thank you. But listen, the heat was on, right? I mean, we'd been putting a lot of pressure on authorities. There was no secret about that. And some people, I guess, probably thought I was too tough on him. But I'm not going to apologize. I write more about it in my book.
So a couple of weeks ago was the 5-year anniversary of Dee's disappearance.
Yes.
April 24th. Did you think you would ever get to this point when that happened? I mean,
that's an interesting question. I don't want to sound egotistical about this, but the answer is yes. I thought we would get to the point because I wasn't stopping. I mean, I guess if you're dead, you stop, right? But other than that, I was not stopping. There was too much information. There was too much evidence. It was a matter of getting the system to utilize the evidence to get this criminal.
Can you tell us a little bit about your sister?
I'm sorry?
Can you tell us a little bit about Dee?
Yeah, I mean, you could ask so many people that would talk about Dee because she really, really wanted everybody to be her best friend. She really did. And my relationship with Dee was, she was this gregarious, lighthearted. she wanted to spar with me all the time, and in a good way, sometimes in a bad way, but generally it was a good way. We highly respected each other, but we were competitive people in a competitive business. So, but I liken her to I had an uncle that was a very wonderful guy, and I called what I considered his best friend after my uncle passed, and he called me, I should say, and he said his name. And he said, "You remember me?" I said, "Well, of course I remember. You were my uncle's best friend." He said, "No." His comment was very similar. He was everybody's best friend, and that's kind of like Dee. She was everybody's best friend, and she practiced that.
What does healing look like now that the verdict is in? Can you move on? How do you move on?
Well, it's a big relief because, what is most troubling to people is the unknown, right? And so till today, it still was an unknown. And we knew that, this mercenary law firm, Mary Chartier, who was doing everything to twist and spin the facts, you can say, well, it's doing her job, okay? But listen, after all the evidence, you're still spinning, okay? I mean, that really is a little bit hard for me to absorb. So it was still an unknown, and to answer your question, it's very relieving to know we have a absolute known. You had enough of me yet?
Thank you. Thank you so much. I appreciate it.
Thank you. Thank you. Listen, by the way, I've said it before, I say it every time I get a chance. You guys in the press, or you ladies in the press, get maligned so many times nowadays, and you've been a wonderful help. Sorry. In this case, I appreciate it.
Thank you, sir. Say and spell your name to start, please.
Parker Hardy, Parker Hardy.
You say to Dale right now, he's watching. Of course, they're in jail.
Good riddance, Dale. We won. You didn't.
What was it like to hear the sentences come?
It was overwhelming. It was nerve-wracking. We wanted it, obviously, to be the maximum possible sentence. And I think we got as close as we could ever get to that. So it was another step of moving forward.
Tell us about your aunt.
My aunt was, as most people probably know at this point, thanks to your wonderful media coverage, was a wonderful, blooming individual. She would be very fierce to you, but also have your back completely if she loved you. She was extremely giving. She wanted everyone in the world to love her. I can't say enough about her. Anybody else? We're good?
Thank you.
You're welcome.
Thank you. Thank you.